Hi, my name is Equitable Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and enlighten the public. So please subscribe to our channel. What is the difference between a military divorce and a non-military divorce with respect to how we divide property? Well, there are differences that have to do with the types of property that fall into the pot, so to speak, the pot to be divided, the marital property. But for the most part, the formulas and the methods by which property is divided is very similar with if you're in a military format or a non-military divorce. I'll give you an example. When we talk about various property that we are going to divide, we're usually talking about houses, money, bank accounts, 401k, IRAs, pensions, these kind of things. Now, people who are servicemen, people who are in the military, they may well have, a pension, a military pension. Is the military pension subject to division as a marital asset? Well, the short answer is accumulated during the marriage. It's going to be in play as we discuss the division of marital assets. So there may be a military pension that has to be considered. Now, like any other pension, does that mean that servicemen or servicewomen who accumulate this pension, that we divide everything up dollar per dollar, half of this, half of that? Not necessarily. Remember, the law requires the judges to give an equitable division of assets, but equitable doesn't always mean equal. It could mean equal, it just depends on certain circumstances. For example, let's say we have a military pension, and now somebody's retired from the military, we have $100,000 in there, it was all accumulated during the marriage. We might well say, well, let's divide it 50-50. But let's say this military pension is all the person has, and that person was disabled as a result of military service during the marriage. So in a situation like that, maybe the court might say, well, you know what? Dividing it at 50-50 might not make sense because this is all this person has to live off of. They're not going to be able to go into civilian employment, so maybe a different division is appropriate. Maybe not. It just depends on what other pension benefits that person may have. But the point is there are considerations when we talk about these things. They are considerations for civilian assets. They are considerations for military assets. You have to understand something too, that when the court looks at dividing up assets, when it divides up liabilities, and one of the things that we also look to is spousal support. You know, the military has specific rules about supporting non-military family members. Now, in a situation where there's a divorce, it's always a consideration. Do we have a spousal support case? Is it an alimony case? And there are factors associated with that. Those factors, though, are going to apply in a military context and in a non-military context. Now, does that mean that you can open up some book somewhere and say, okay, this is the formula, this is what the table says, therefore that's what you pay? Not necessarily. There are always considerations that the court uses in determining what's equitable. If you have any questions about your case, reach out and we'll be glad to help you out.